and now I'm adding myself so you can see me, remote work considerations in terms of alternatives to the H-1B cap. So this is our last series in this particular video on H-1B alternatives, or in this particular series of videos on H-1B alternatives. It may seem counterintuitive to think about sending foreign national talent that you have worked so hard to recruit and retain and attract to work overseas, but it can be a key element of a strategic plan, longer term strategic plan to ultimately reach your US immigration goals in terms of this foreign national talent. So let's talk about what the options are and why you might send somebody overseas, at least for a period of time, to work. One is the L1 visa option. We talked about the L1 visa option in a previous video when we talked about non-immigrant visa alternatives or temporary visa alternatives to the H-1B. The L is one of the options that is an alternative to the H-1B if you meet certain qualifications for it. But one of the key qualifications is that the foreign national employee has to have worked at a related entity. There has to be a qualifying corporate relationship, but at a related entity overseas for at least 1 year of the past 3. That does not mean that they have to be a citizen of that country, but they do have to have worked at that overseas entity. So let's say that you have an overseas entity in France, just making this up, and your foreign national is from India, for example. There might be visa considerations, of course, to getting them to work in France, but if you can have them work at the office in France, and if they otherwise qualify, and if the company otherwise qualifies for the L1, it might be long-term in the best interest to have them work in that overseas office in France, for example, for a year, and then bring them over to the United States. So this is one possibility. Or one reason that you might send a foreign national employee overseas, at least temporarily, as an alternative to the H-1B. Another reason that you might send somebody to work overseas for a period of time is to let the employment-based green card process play out. We talked last week about the employment-based green card process or processes options as a potential alternative to the H-1B. And I was saying last week that that process does take longer now than it has in the past. So it is possible that your foreign national employee could be overseas for longer than you would like or anticipate. But let's say that you start the process at the beginning, the employment-based green card process. Let's say as soon as you find out that they were not selected for the H-1B, the first round. So they're on the first 12 months of OPT, you file them or register in the H-1B lottery, they're not selected, and you begin the green card process. If they are eligible for STEM OPT, they have another couple of years, so a total of 3 years to work in the United States, and you begin the green card process. If you are not at a certain point in that green card process, if you don't reach the point where they're able to file what's called the I-485 and obtain a work authorization document, then I have had clients in some situations who have sent those employees overseas. They've said, you know what, this is the best option for right now, work overseas, and let's wait out the rest of the green card process. I think that I've mentioned before a kind of success story in this realm where we had a client, a corporate client, who had their employee go overseas. There really wasn't another viable option for them. So they had their employee go overseas. We were well into the green card process. It was year 3 of registering for the H-1B lottery. This particular employee was actually selected in the second round of the H-1B lottery last year. So first round, March last year, we thought, oh my goodness, third try at the H-1B lottery, and they still weren't selected, but they were selected in the second round of the lottery last year. Again, we don't know if there's going to be a second round this year. I'm thinking not, but we'll see. So he was selected, and he was able to come to the United States in H-1B status, but he also was able to file the I-485, the application for the green card, shortly after entering the United States, because the employer had selected or had chosen to pursue multiple options at the same time. So he was in a really great place. He is in a really great place right now, still working in H-1B status for this company. He's doing a great job. They're happy to have him, and he's thrilled because he's close to the point of actually receiving the green card. So whether that happens or not, whether the person is actually, the worker is actually selected finally in the H-1B lottery or not, you still can have the employee wait out the process overseas. We've had lots of clients do that over the years. And it is possible to obtain what is called an immigrant visa at the US consulate overseas, use that to enter the United States. Once that process would be in place of the I-485. So it's towards the end of the green card process. When a green card is available, they would obtain the immigrant visa and use that to enter the United States. When they enter the US, they would enter as a permanent resident of the United States, and they would be able to resume working immediately and receive their green card in the mail. So that is a possibility, even though the processing of the timeline might take longer than you actually want it to. Another option, and like I said, you can pursue multiple of these options at the same time, but another option is to have the employee work overseas and register them in the H-1B lottery again next year, and see what happens. Maybe you're sending an employee overseas to meet the L requirement, the requirement for the 1-year experience in an overseas office, but at the same time, you also register them in the H-1B lottery again this coming year to see what happens. Or maybe you send them overseas because the green card process is playing out and you also register them in the H-1B lottery, which is what I was just saying a minute ago, telling the story of how that happened to one of our clients. So you can register them in the H-1B lottery again. One thing to keep in mind, if an employee is working for you overseas, they can work as a contractor, they can work as an employee. Because they are not physically present in the United States, you do not have to I-9 them and make sure that they have valid US immigration documentation if they are physically present outside of the United States. There are other considerations as well. So of course, you need to make sure that you are looking into and adhering to employment law that's relevant for you here in the United States and for them wherever they're working. You would have to look into tax implications, payroll implications, and of course, depending on where the person is, they may have a whole nother set of immigration opportunities, let's say challenges in the other country if it's not their home country. So there are other considerations. This is not an easy solution by any means, but it is one that lots of clients have taken and it can be an option. And then finally, another reason that you might send an employee overseas to work temporarily is if they are working on citizenship for another country. So we've actually had this happen pretty frequently as well, not infrequently, I'll say, that a person is born in some other country, let's say Pakistan, China, whatever country it is, and they are working on obtaining their citizenship in Canada. That is a separate process from US immigration law, of course, 2 separate countries. But once they receive their Canadian citizenship, they are then eligible for the TN visa classification or the TN classification. And again, there's a separate video on TNs that we have in our Sumner School Business Immigration series. And we talked a little bit about it in a previous video on non-immigrant visa options. But that is an option. The TN is an option to come to the United States and work temporarily. It's a temporary visa classification, but temporary can be for years on end. So that I've had that happen before as well, where an employee will spend some time in Canada, perhaps work remotely for the US employer and work on getting their Canadian citizenship and then pivot, if you will, to come to the US in TN and then eventually have a longer term immigration plan for here in the United States. Like I said, this is not necessarily an easy solution. I don't like using the word easy in any context really in US immigration. There are payroll implications, there are employment law implications for sure that you have to make sure that you are looking at and adhering to, but it can be a possibility. My point here is throughout these 3 videos that we've done on alternatives to the H-1B is that there absolutely are alternatives to the H-1B. Just because a person was not selected in the H-1B lottery does not mean that they should pack their bags and move overseas forever. And they shouldn't go to Canada necessarily forever. That might be their option, but I hope it's not, because we want this talent to stay in the United States and enrich the fabric of our nation. So I hope that you have found these videos helpful. I hope that you will subscribe to the channel or the platform, our channel that you're watching this on, and catch us next time, which will be next Tuesday, noon Eastern at noon Eastern. I need to eat lunch. Next Tuesday at noon Eastern, when we will talk about another topic in US immigration law. Until then, my name is Emily Sumner with Sumner Immigration Law, serving clients throughout the United States and from around the world with employment-based and family-based immigration matters. Until next time, we'll see you then.